Behind the gleaming towers of the construction industry lies a shadow network built not on bricks and mortar but on fear and obfuscation. At the center of this machinery stands Ogletree Deakins, the employment law powerhouse whose polished veneer masks a reputation for crushing dissent and shielding corporate wrongdoing, especially in construction. When a worker files a complaint about discrimination, when a job applicant points out a fraudulent hiring scheme, or when a fired employee leaves a review exposing retaliation, Ogletree Deakins does not ask what went wrong. They ask how they can shut it down. Their lawyers draft cease-and-desist letters dripping with menace, threatening defamation suits they know will never survive in court. They whisper to employers about problem candidates, planting seeds that a whistleblower is nothing more than a disgruntled troublemaker. They bury individuals under the weight of legal jargon, counting on fear and exhaustion to do the rest. It is not about truth, it is about intimidation. The irony is that Ogletree Deakins itself has been accused of the very practices it defends. Female shareholders within the firm filed a lawsuit alleging gender discrimination, accusing the firm of paying women less than their male counterparts, denying them advancement opportunities, and crediting origination fees to men even when women brought in the clients. The lawsuit pulled back the curtain on a culture that mirrored the same inequities Ogletree helps its clients conceal. At the same time, its attorneys have been instrumental in defending construction firms against prevailing wage and apprenticeship claims, defeating class certification in cases where systemic violations were alleged. These victories, while celebrated by corporate clients, also highlight the firm's central role in preventing workers from banding together and exposing exploitation on a larger scale. This is the same firm that has been called upon in high-profile union-busting campaigns, even hired by the ACLU during a union drive, sparking outrage among supporters who saw the move as hypocrisy. If Ogletree Deakins will fight to suppress unionizing efforts in progressive organizations, it is not hard to imagine the ferocity they deploy to protect construction giants accused of fraudulent hiring, retaliation, and unsafe practices. Their entire model depends on silencing the first voice before it becomes a chorus. A single negative Google review is not just reputational damage, it is a breadcrumb trail that regulators and journalists can follow. One LinkedIn post is not just criticism, it is evidence waiting to be collected. And this is what they fear. Construction companies survive on contracts, many of them public, and a single finding of discrimination by the EEOC or retaliation by the Department of Labor can strip them of eligibility overnight. An OSHA investigation into whistleblower retaliation can become a matter of federal record. A licensing board inquiry can threaten the right to operate at all. Ogletree Deakins knows that once a complaint reaches a government agency, they lose control of the narrative. Their letters cannot silence a subpoena. Their posturing cannot intimidate investigators. The fortress of intimidation they build around their clients crumbles the moment transparency and enforcement arrive. That is why they strike so hard and so fast against individuals. They understand that the real threat is not one worker speaking out, but many. If even one case of retaliation or fraudulent hiring is validated by an agency, it sets a precedent. It tells other workers that they are not powerless, that silence is not their only option, and that even the most intimidating firm can be beaten. This is the nightmare scenario for Ogletree Deakins and the companies they protect. The image of invulnerability they project is just that, an image. Behind it lies deep anxiety that the truth, once exposed, will shatter the illusion and bring down not just one case, but the entire corrupt business model they have spent decades protecting. They can silence individuals, but they cannot silence the law. They can bury critics in letters, but they cannot bury subpoenas. And as history has shown, the louder they shout, the more they reveal just how much they have to lose. More to come. Thanks for watching.